New York State child support initially is calculated by something called the Child Support Standards Act, the acronym CSSA. And what it is a formula that the combined parental income of both parties, both parents, with certain deductions, typically FICA and Medicare, results in what we call income for child support purposes. That income is then multiplied by a certain percentage depending on how many children are under the age of 21 or who are unemancipated. For one child, it's 17%. For two children, it's 25%. For three children, it's 29%. For four children, it's 31%. And for five or more children, is not less than 35%. That calculation would result in what the legislature has said is the presumptively correct amount of child support to be paid from the non-custodial parent to the custodial parent. However, parties are free to opt out of the guidelines and fashion their own child support obligation. The statute does not prevent people from doing that. However, if that is to happen, the agreement must set forth the calculations and what would have been the amount of child support to be paid and the reasons the parties are deviating from that presumptive correct amount. Also, right now, the combined parental income is capped at $143,000 and is tied into the social services law. So it will go up. It has gone up and it will go up. Courts, though, do not have to be bound by the statutory cap. And courts, at least here in the Second Department, routinely applied the percentages to income greater than the statutory cap of $143,000. That deals with base child support. We then have what we call the statutory add-ons, such as health care for the children, the unreimbursed, uncovered health care expenses of the children, child care costs to allow the non-custodial parent to go to work or continue his or her education that will lead to employment in the future. Those are the statutory add-ons. How those are paid, if you follow the statute, is in proportion to each parent's income. So let's say the father, in this case it's a non-custodial parent, makes 60% of the family income. His pro rata share of the statutory add-ons would be 60% and the mother's 40% if the parties agreed to follow the CSSA to the letter and not deviate.